Last week, the Supreme Court got rid of a 40-year-old doctrine called Chevron Deference, and in doing so, it hugely impacted the way government works for you on a daily basis. Today, I'm going to talk about the administrative agencies that do much of the work of government, the separation of powers between the executive, judicial, and legislative branches of government, and the Supreme Court's decision in Loper Bright versus Raimondo, which is a sea change in how administrative agencies can interpret laws passed by Congress to make regulations and rules that affect you in your day-to-day life. Our government has three branches: the legislative branch, Congress, which passes the laws; the executive branch, the president, which implements and enforces the laws; and the courts, the judicial branch, which interprets the laws and adjudicates disputes surrounding the laws. The main way in which the executive branch implements and enforces the laws is through its administrative agencies. And there are almost 450 administrative agencies under the executive branch that you may have heard of as regulatory bodies. They make rules and regulations, and they have processes in place to do the day-to-day work of government. Some of these include the Food and Drug Administration, the FDA, which regulates food safety and drug safety, makes sure that the food you eat doesn't have poison in it, that the drugs you take are effective and don't have crazy side effects. The Centers for Medicaid and Medicare Services, CMS, which administers Medicare and Medicaid and health coverage for millions of seniors and low-income individuals in the United States. And then there are some that you may not have heard of, like the National Oceanic Atmospheric Administration, or NOAA. They are in charge of climate monitoring. And when you pick up your phone and look at the weather, that's where your daily weather forecast is coming from. So administrative agencies do a ton of stuff, and to do that stuff, they have to make rules and regulations to spell out areas that aren't necessarily clear from the laws Congress passes. These administrative agencies are generally run by political appointees, but the people actually running the day-to-day of these agencies are generally civil servants, people who have specialized areas of expertise and who are in these particular agencies because they bring that expertise to bear to determine how to enforce and implement the laws that relate to that sphere or that subject matter. The idea behind these administrative agencies is that when Congress passes a law that applies to a specific subject matter area, it delegates some power to the executive branch, to these administrative agencies, to take that law and to turn it into regulations and rules so the executive branch can more effectively carry out the law to its intended purpose. Now, most people agree that some amount of regulation is a good thing. We want the government to make sure our food is safe. We want the government to make sure that the doors of our airplanes aren't flying off at 30,000 feet. The disagreement is how much regulation is the right amount of regulation, and there's a huge amount of disagreement there. The argument about how much regulation is too much regulation often comes back to the idea of the separation of powers between the three branches of government: the executive, the legislative, and the judicial. This separation of powers was a safeguard against tyranny, crafted by revolutionaries who had escaped out from under a system where the monarchy held a disproportionate amount of the power. And they wanted to make sure that our system of government wouldn't fall prey to the same issue of consolidation of power in any one branch of the government. Administrative agencies are sometimes called the fourth branch of government because they have the power to make rules and regulations. That's sort of a power Congress usually has. They've got the power to enforce those rules, which is the power of the executive, and they've got the power to adjudicate certain disputes that arise under those rules and regulations, which is sort of a judiciary function. That combining of legislative, executive, and judiciary functions all under the president, under the executive, is viewed by some as a consolidation of power under one branch outside the scope of what's specifically outlined in the Constitution. When Congress delegates to the administrative agencies the power for them to rule make and to carry out the law, it also consolidates a little bit of power under the executive branch that would otherwise only be held by the legislature or the judiciary. The agencies need that power to carry out the day-to-day tasks of running the government in a way that benefits you and me. And there isn't so much a concern about tyranny like the founders were concerned about, because that power is spread across hundreds of administrative agencies and thousands of career civil servants who have been in those agencies for their entire careers. And yet any gradual consolidation of power within one branch creates concerns among the other branches and creates a pendulum that after a certain period of time, will swing back in the other direction. And that's something that's apparent in the Supreme Court's most recent decision in Loper Bright versus Raimondo. For the past 40 years, courts have followed a doctrine of judicial deference to the administrative agencies that interpret ambiguities in laws created by Congress. When Congress passes a law that deals with a specific subject matter area, the administrative agency tasked with overseeing that area is given the power to make rules and regulations to basically fill in the gaps in the law, because the administrative agencies have the specialized expertise to do that. For example, the Federal Aviation Administration, the FAA, that deals with air travel. Congress passes a law creating the FAA and tasking it with promoting a safe flight for civilian aircraft in the United States. The FAA then gets to figure out, what exactly does safe mean? And to do that, they turn to their experts, whom they hire. And they build a series of standards and regulations and rules that deal with everything from pilot certification standards to aircraft design, aircraft maintenance, so that there are hundreds and thousands and tens of thousands of regulations that all go towards making sure that aircrafts and flight in the United States is safe. Now, the FAA recently has been tasked with potentially coming up with regulations that have to do with minimum design standards for seats on airplanes. Suppose the FAA comes up with a regulation that says you can't have airline seats that recline because that creates issues for safety and makes it more difficult in the event of an evacuation. And so the FAA promulgates a rule that says aircrafts that are manufactured or used in the United States cannot have seats that recline. Airline companies get together and they say, well, this is crazy. It is creating a ton of discomfort among our passengers, and we're losing all of our goodwill among our passengers. And people are just going to start taking the train and not flying anymore. So they sue, they challenge the regulation. The FAA, your interpretation of safety in the statute that Congress passed is way off. You are going beyond the scope of that statute. Now, for the last 40 years, the courts have a two-step test to address those kinds of disputes. It's called the Chevron test. Step one, is the language of the statute ambiguous? Is the word safe or safety ambiguous? Does the law have any other specific requirements or definitions of that word, or does it not? And if it doesn't, if it is ambiguous, then is the agency's interpretation reasonable? In that, is it justified and supported by a rationale? And in this case, the FAA might put forward, as a part of the rulemaking process, tons and tons of documentation and testimony from experts and people in the field and design standards, all leading up to the conclusion that reclining seats are dangerous in the event of evacuations. And under the Chevron deference doctrine, a court would say, okay, FAA, you have reasons. We are going to defer to you and your specialized expertise in this area in interpreting that law. There are very good reasons for judicial deference under the Chevron test. We want to make sure that the experts in those fields are interpreting the laws that relate to those fields. We want to make sure that the administrative agencies that have the most experience with actually enforcing and implementing the laws have not just a say, but have a huge say in how those laws are interpreted. And until last week, that's exactly what would have happened. But then the Supreme Court threw a wrench into things. The Supreme Court's decision in Loper Bright was a huge change in the way that courts look at administrative interpretations of the law. Loper Bright involved fishing companies that brought a lawsuit to challenge a regulation set forth by the National Marine Fisheries Service. The rule was as follows. There is a law that has to do with the conservation and sustainability of fishing. And so in implementing that law, the National Marine Fisheries Service made a rule that said you have to have observers on your fishing boats when you're at sea to make sure that you're meeting the requirements of these specific fishery management plans that are targeted towards sustainable fishing. You've got to have someone on board to make sure you're doing things according to these plans. The question was, who pays for those observers? The statute, the congressional statute, doesn't talk about it. And so the National Marine Fisheries Service made a regulation saying the fishing companies have to pay for the observer. The fishing companies said that's outside the scope of the language in the statute. Your interpretation, National Marine Fisheries Service, is wrong. So what happens? The federal district court that first had the case did exactly what courts have done for 40 years. Under the Chevron deference test, it looked at whether the agency had a rationale, whether it had reasons behind that rule, and it found it did. So however the judge felt about whether or not it was right or it was even a correct interpretation of the law to make the fishing companies pay for it, under the Chevron deference test, the court essentially was saying, you, National Marine Fisheries Service, have more experience with how all this works in the context of these conservation acts and how fisheries and fishing companies work. You are better suited to sort of make the call on what Congress intended and what will best accomplish the language of the statute. This went all the way up to the Supreme Court. Supreme Court overturned Chevron and said, no, we, the judicial branch, should not be deferring to the executive branch on the meaning of the law. It is within the umbrella of the judicial branch to say what the laws mean. In doing so, the court effectively redistributed a certain amount of power that for decades has been held by the executive branch in its administrative agencies and reallocated it to the judicial branch. So the judicial branch has the say on what these laws mean, even if they're laws that are in very specialized areas and within the scope of these administrative agencies. The courts have the say on whether essentially these regulations are true to the statute or not. The question raised by the Supreme Court's decision in Loper Bright, overturning Chevron, is should federal courts be the ones making the call on what these statutes mean in the context of these specialized areas that are delegated to administrative agencies? Or should the administrative agencies be the ones to make the call based on their expertise of actually carrying out these laws and their subject matter expertise in these areas? On one hand, it's important for the interpretation of the laws to be done by the judicial branch, a separate branch of government than the branch that's tasked with enforcing the laws. And this can especially be true where there is some level of instability in the executive branch. For example, the turnover over 4, 8, and 12 years of administrations that are diametrically opposed to each other from a policy perspective. Well, that can create a lot of instability, especially when it comes to the administrative agencies that those executives control. And that back and forth change in regulations can have very real impacts close to the ground for the entities like, say, school districts that are responsible for following them, making their own processes that accord with those regulations just to keep the people and kids in their scope of responsibility safe. On the other hand, federal judges aren't appointed for their specialized expertise in composite material design or healthcare management. They're appointed to make judgment calls based on the facts that they're provided. And yes, they will get a lot of expert information in the form of testimony and documents in a lawsuit that challenges an agency's interpretation, but they're going to get it from both sides. And so there's always going to be a battle of the experts. And everybody knows that if there's an expert saying one thing, there is an expert saying the opposite thing. And so federal judges have to make the call. The way they make the call as to which expert opinion is correct is not based on the scientific or technical accuracy or fidelity of what they're saying. It's based on their credibility. It's more complicated than that, but generally speaking, that's how judges decide. And so there is a very real fear that given competing expert testimonies in the adversarial context of a lawsuit, a federal judge could very well put their thumb on the scale and, whether consciously or subconsciously, let their own policy perspectives and motivations sort of overlay the decision on which expert is giving the right or the most credible information and guiding the interpretation of that particular statute. And that's precisely what Chevron deference was meant to avoid federal judges from putting their own policy perspectives onto interpretations of the law in specialized areas. In that sense, Chevron deference strengthened the separation of powers because it was a structural safeguard against judges being policymakers. And yet here, for very similar reasons about the separation of powers, the court has rolled back Chevron deference in a way that has consolidated more power into the judiciary. And it's not the first time it's happened. The Supreme Court didn't always have the power that it's most known for now, the power of judicial review, the power to determine whether a law is unconstitutional or invalid. And the way that it got that power is a crazy story. In 1800, Thomas Jefferson beats John Adams for the presidency. By the way, marking the first ever peaceful transfer of power between political parties. John Adams, who is still president until midnight, decides to appoint a bunch of judges under the Judiciary Act, which at the time allowed the president to appoint judges. So he does. And he appoints William Marbury as the Justice of Peace for the District of Columbia, just a judge. Before the stroke of midnight, John Adams signs Marbury's commission. But that commission doesn't get delivered before John Adams has to leave office. Thomas Jefferson takes office, and the first thing he does is to tell his Secretary of State, James Madison, not to deliver any undelivered commissions. So William Marbury's commission is never delivered. William Marbury is mad. He files a petition with the Supreme Court. See, the Judiciary Act also gave the Supreme Court the power to enforce those judicial appointments through a process called a writ of mandamus. It's a document that says, you have to appoint this person. So Marbury files a petition for a writ. Now the court is in an impossible dilemma. If it orders James Madison to deliver the commission and he refuses, it shows the country that the Supreme Court is weak and has no power over the executive branch. If the court does nothing, well, it shows the country that the court doesn't have the power to check the executive branch. It is a lose-lose. And so the Chief Justice comes up with a tactically genius move. Writing the decision for the court, he says, we will not issue the writ of mandamus because actually we have no power to do it. The part of the Judiciary Act that says the Supreme Court can issue this writ, that part is unconstitutional and invalid. It goes way beyond the separation of powers. It goes way beyond the powers laid out in the Constitution. And because it's our duty and authority as the Supreme Court to interpret the laws and make sure they abide by the Constitution, we are looking at this law and saying it is not constitutional. We don't have the power to force the appointment of Marbury. And so the Supreme Court avoided a confrontation with Thomas Jefferson's administration by giving Jefferson exactly what he wanted, which was to not have Marbury appointed. Because Jefferson didn't push back because he was happy with the outcome, it cemented this idea that it's the Supreme Court's role and authority to interpret laws and make sure they abide by the Constitution, that the Supreme Court has the power to determine whether laws are constitutional or not. That was not a thing in the Constitution. People generally thought the judicial branch was the weakest of the branches. No one had ever said, and we are going to create a judicial branch that has the power of judicial review to make sure all the laws follow the Constitution. No, the Supreme Court gave itself that power in a politically brilliant move that cemented it as just as powerful as the other three branches. And that has formed the bedrock for our conception of the separation of powers in this country for the last 200 years. Now, it's probably a little dramatic to say that Loper Bright is the next Marbury, but there is a reason that the court cited and quoted Marbury versus Madison in the opinion. It's probably better left to smarter people than me to try and determine the political motives of the Supreme Court, but you're watching me, so I'll just tell you what I think. On one hand, getting rid of Chevron is part of a longer-term conservative campaign to push back against what's seen as overregulation. And that's very clear when you look at the ideological lines along which this opinion came down. 6-3 conservative justices to liberal justices. But on the other hand, it's interesting to see this decision in the span of the same week when the court comes out with the decision saying that a president is presumed immune for official actions taken while in office. Looking at Loper Bright from the same lens that we now view Marbury versus Madison, the argument could be made that Chief Justice Roberts is looking at the political landscape here and making a call, taking a gamble, that if the Supreme Court issues a decision on presidential immunity that doesn't make an enemy out of Donald Trump, in the same way that the Marbury decision didn't make an enemy out of Jefferson, and at the same time also consolidates power from the executive to the judiciary, then the Supreme Court has given itself the power it needs to operate as a more effective check on a capricious executive that might direct administrative agencies to interpret laws in a way that is counterproductive to the health and welfare of the citizenry, and has done so without making an enemy of a president who might do that. If that is the case, it is a huge gamble because it comes at the expense of consistency and stability in the way government functions through administrative agencies. And we won't even know if the payoff was worth it for many, many years until we can look at this decision through the lens of history. Whatever the case, this is probably not the last time this issue is going to come up before the Supreme Court in the near future, because the court is going to have to provide guidance to the lower courts on how exactly they should be interpreting these statutes and whether they should be giving any deference to the opinions of the administrative agencies and the experts there. So, when the next case comes out dealing with this issue, you can bet I'll make a video on it, and hopefully it'll be just as entertaining as this one.